The issue of battle of the forms often baffles some students and leads to a confusion that they're perhaps dealing with a new area of law. And this is largely engendered by the way certain courses are taught or the way the subjects are approached in some textbooks. The starting point has to be, when dealing with battle of the forms, to understand that the issues around battle of the forms are areas the students by this point will have already covered. So the rules of offer, the rules of counter-offer, the rules of acceptance, and in the wider sense to include acceptance by conduct. So what is battle of the forms? Well, it arises most often in situations where one party wants to contract on their standard terms already in a printed document, and the other party also wants to contract on their own standard terms already printed. Now, unless there's a miracle, there won't be identical terms in both of those standard term contracts. And this can lead to disputes as to whether a term is incorporated in the contract or whether particular terms are incorporated. And instead of calling it a dispute, it's just called a battle of those two contracts or a battle of the forms. So the things to look out for, the issues that you would need to have in your tool bag in the examination when you get a question on battle of the forms will be, you'll have to understand the rules of offer and the cases that go with it. You'll have to understand the rules of counter-offer and what effect that has on an offer. And you'll have to understand the rules of acceptance. And in this context, we're looking at seeing signing a contract can amount to the accepting the terms that you thought you weren't bound by. You thought you were bound by the terms of your contract. Or it could be that after delivery, your delivery note, which has your terms on it, is stamped by the person who's receiving the goods and it's on their terms. Or it could be that it's acceptance by conduct, that having not recognised that there's a difference in certain terms, you go on, you take delivery and you pay for it. Students will have to also take into account the way courts go with these cases. So, for example, you can have a court that makes a decision at High Court level that a disputed term is incorporated, and it goes on appeal to the Court of Appeal, and the Court of Appeal says, no, it isn't. And then it's appealed to the Supreme Court, and the Supreme Court reinstates the High Court case and says, yes, it is incorporated, and yet it's the same case with the same set of facts. Now, no examination question is going to have a set of facts that fit precisely within any given case, and so the student is going to be able to have to argue both ways. And of course, you have to recognise that certainty of terms can also form part of the matrix of battle of the forms. So your knowledge around certainty of terms must be good for application of a good answer.